appoint again?
We'll appoint the same lawyer. You waive the reading, Mr. Reardon?
Yes, Your Honor. I do waive the reading, but on the new case, I don't think I can be appointed. That I asked that Mr. Cusiak be appointed because the witness in this new case is a victim in the case that currently pens, and I want tomorrow with that case, Your Honor.
All right, well, we best agree. Why would I read this?
Complaints against you, sir, numbers 1048 CR 1563, alleged assault with a dangerous weapon, assault and battery, threatening to commit a crime, and possession of a Class A drug subsequent offense.
Okay, you're entitled to have a lawyer now. We'll appoint an attorney. We'll appoint CPCS.
I had that conversation, so thank you, Judge. We'll take that early. Your Honor, this is a question of bail.
It is a question of bail?
Yes, Your Honor.
Are you ready?
Yes.
All right, now, he has two cases, and you represent him on one?
Yes, Your Honor, and on that, we would do back tomorrow with the Judge Kunis ordered that the victim come in tomorrow to speak to the court, appear before the court. Otherwise, the case would be dismissed. My understanding, the victim is here as a witness on this case, and the district attorneys need to speak to her about a Fifth Amendment privilege, but we don't have another attorney available today. So I think tomorrow I'll just come in and ask for continuance.
But wouldn't it be best just to get one lawyer on everything?
I can't represent both, so I'd have to withdraw from the case I'm on.
Why don't we appoint CPCS on both? All right with you?
That's fine.
There's no sense having two lawyers.
But the same conflict would stand, Your Honor.
What's the conflict?
The conflict is that the victim on my case, Christina Rogers, is a witness for Mr. Vazquez on the assault and battery or some other individual today. So again, she's a witness and a victim. And that's why I can't represent both. So I don't think the CPCS can do justice on either side.
Do you agree that's the situation?
The situation is on the case that's pending in Ayer District Court right now. The victim on that case is Christina Rogers. Then in this case, the new arraignment, the witness for the defendant is Ms. Christina Rogers.
I see. All right, well, we've got to keep two different lawyers then.
Yes.
All right, why don't we go forward on the bail here?
Thank you, Your Honor. Here, the Commonwealth is asking for $1,000 cash bail with conditions of no abuse, checking with probation once a week, random drug screens, and bail warnings. This is based on the facts of this case in the defendant's record. Briefly, Judge, on November 9, 2010, at approximately 1 a.m., the Ayer Police Department was dispatched to 10 Oak Street for a report of a disturbance involving tenants and a landlord. Upon arrival, they spoke with the alleged victim in the case, Mr. Moulton. Mr. Moulton appeared to the officers had been consuming alcohol. He told the officers that he believed that his Viking was missing from his room and that he believed that Mr. Vazquez had taken the medication. At this point, he went upstairs to confront Mr. Vazquez about the medication in an argument that ensued, where the victim allegedly states that he was punched in the face by the defendant. The defendant produced a folding knife and began to stab him. He said that he was threatened, that the defendant threatened to kill him at that time and continued to punch him in the face. The officers did notice blood drops on the floor. They then approached Mr. Vazquez, who had a folding knife flipped to the front of his front pants pocket. The officers were able to get that folding knife from the defendant. Later, during booking in the defendant's wallet, an inventory of his wallet revealed a small plastic baggie which contained a small motor baton substance the police believed to be heroin. Judge, those are essentially the facts of the case. However, it should be noted that upon arrival, the Ayer Police did speak to Ms. Vazquez and Mr. Vazquez and Ms. Rogers about this incident. They state that it was Mr. Moulton who attacked the defendant with the knife, and it was Mr. Moulton who punched Mr. Vazquez. So it does seem to be two sides to the story, Judge. However, based on the facts, turning to the defendant's record, the defendant currently has an assault and battery and witness intimidation open out of this court with Ms. Rogers as the victim. As you can see from his record, he has served committed time for possession of Class A. Both of the cases currently open, and in prior cases in 2007 out of this court, as well as in Worcester District Court in 2007 after a violation of probation where he received 6 months committed. Also, if you look at his record, he has prior convictions for assault and battery and assault, where he has numerous defaults in those cases, and he's been convicted after violations of probation in those cases. He also has defaults in his record for crimes such as shoplifting, and he has served prior committed time in 2001 out of Ayer District Court on B&E and larcenies, as well as prior quaffs for possession of Class D, in which he has violations of probation on those crimes too. Judge, based on the facts of this case, facts alleged are violent in nature, based on the nature of the defendant's record, the amount of defaults, the amount of violations of probation, and the amount of committed time on the defendant's record, the Commonwealth believes that $1,000 cash bail and the conditions previously set forth would be appropriate. Thank you.
All right, thank you. All right, do you want to go ahead?
Yes, Judge. Mr. Vazquez was living at 10 Oak Street in Ayer. It seems to me this is a rooming house where the landlord may have been involved in this incident. There are two individuals, Brian Bolton and Brian Zagamore, I think is the last name. He's renting out the room to five bedrooms there. Mr. Vazquez did leave that address and is now staying at 10 Vernon Street in Ayer, Mass. with his uncle Hector. Although he only went through the 10th grade, he has received his GED and was working at Landscaping Act in Massachusetts. Unfortunately, due to he had received a gunshot wound in his knee and is now currently receiving disability, is unable to work, does not receive much money. His girlfriend, who is present in the courtroom today, Christina Rogers, was a witness both to this case and is the alleged victim to the other case in which Attorney Reardon has. The Commonwealth does cite that case on the Board of Probation record. It seems as though that case is going away and that they would be unable to go forward on that issue. Regarding the facts of this case, it seems as though it's ripe with Fifth Amendment issues. There's an amount of blood found in different rooms of the house. Miss Rogers does have a sweatshirt on with bloodstains on it. There's allegations of a knife found in the house and a knife found on Mr. Vazquez. Who those knives, the knife in the house belongs to is unclear. It seems as though the police in this case arrested Mr. Vazquez without taking a statement from him. He also had injuries, along with Miss Rogers had injuries. It's unclear whether the Commonwealth would even be able to go forward on this case. He did make $100 cash bail last night from the police station. I would ask that cash bail stand, and that if Your Honor is wanting more, that Mr. Vazquez will be willing to be released on conditions that he report to probation with screens, how often Your Honor wishes him to report.
All right, thank you. Okay. All right, after hearing, I'm going to set bill in the amount of $100 cash, 1,000 jury previously posted. And he's to have no contact with Mr. Bolton, to stay away from where he lives. He's to consume no alcohol or illegal drugs and submit to random testing determined by probation. Does he want to agree to those conditions?
He'll agree, yes, Judge.
No, I don't know if Mr. Vazquez realizes that the testing protocol would involve paying for the tests, if that's the issue or not.
I don't believe that would be an issue. I think that it's $12 of testing. I don't think that would be a problem.
You understand now, if there's any further trouble, if you violate any of these terms or conditions, then you could be held in a no-bail sentence.
Yes, I understand that, sir. I would just like to see it.
Okay, so what date would you like, counsel?
If we could have January 12th for pre-trial.
Is that all right? So, I don't have time. All right, now, what is the Commonwealth proposing to do with this other case?
So Attorney Reardon and I were just discussing that. I think it makes the most sense to keep it on tomorrow, have everyone come back. We can have the fifth evaluated for him and go from there.
So the only charges left is 2 and 3?
Yes, Judge, the assault battery of the witness.
And you want it on tomorrow?
It was already on, and I believe...
No, but you want to stay on tomorrow?
Yes, please.
Yes, please.
Yes, docket number 104ACR1563. That matter stands continued until January 12, 2011 for pretrial conference. The $100 bill that was previously posted is to stand. Attorney Kuzak has been appointed to represent you in this matter. You have to pay a fee of $150 towards that representation. Those monies are due on or before January 12th. You also have the conditions of no contact and stay away from the victim, no alcohol or drugs, and undergo random testing. And docket number 104HCR911, that remains on the list for November 10th. That's tomorrow, sir. Please check into the cashier's office.
Okay, so make sure you're on time tomorrow.
I'll be
You
here.
were very late for that.
It's 9 o'clock, correct?
Yeah, then you have to go in and see probation with the lawyer.
So 9 o'clock tomorrow, correct?
Check with the lawyer, 9 o'clock. That's the latest.
Thank you, Your Honor, Madam Clerk.
Thank you.